Hawaii years were particularly flourishing years for the Law of the Sea Institute, and they offer a marvelous body of data and ideas for us to ponder, and we're fortunate that Sherry Broder has agreed to undertake that formidable task for us, and look forward to hearing from you. So, welcome.
Years in Hawaii and the many important discussions that were had at that time. During that period, there was a very close association with the Law of the Sea Institute, the law school, and also the East-West Center. And I think being associated with the East-West Center in those years was very important because a lot of different scholars from Asia and the Pacific Islands were there at the East-West Center, and that allowed, I think, the Hawaii Law of the Sea Institute a very fertile ground for finding great scholars who knew about the issues facing the Pacific. And so I think when moving from Rhode Island to Hawaii, changed the focus a bit from Europe and the Atlantic to the Pacific and Asia. And of course, at the East-West Center, there were the wonderful meeting rooms at the Inman Convention Center, which is a facility designed by Ian Pei, a very famous architect. There were rooms to hold 60 people and have wonderful conversations. In addition, the Sea Grant was very generous in its support of the Law of the Sea Institute at that time. And I think that also made a big difference. The Hawaii people did raise funds for many other different entities, but knowing that the Law of the Sea, that the Sea Grant was there was very, very helpful. So I'm going to talk about the many conferences that were held in the 19 years of the Law of the Sea Institute. Harry asked me to concentrate more on deep seabed mining and maritime delimitations and other things, but said that other people, such as James Kraska, would be talking about national security issues, and other people, such as Craig Allen, would be talking about fisheries. So I don't mean to leave those out, but that's how, it's all Harry's fault if there's anything missing that you wanted me to talk about. Okay, well, since it was in Hawaii, I'm showing beautiful pictures taken by my son, Eric Broder Van Dyke, who is here today. So here, I met up with some of the people who used to be involved in the Law of the Sea Institute, and they gave me access to their photographs, so I was able to find some great photographs, although most of them were on the somewhat amateurish side. So here are the founders of the Law of the Sea Institute, actually at a conference that was associated with the Institute when it was in Hawaii. So when the Law of the Sea Institute moved to Hawaii in 1977, John Craven was appointed the director. He was a former chief scientist, special projects of the U.S. Navy. He was involved in recovering the hydrogen bomb off the coast of Spain and the USS Scorpion submarine. He was a scientist, a great innovator, and his findings led to new types of espionage for the United States of America using submarines. He also founded the Hawaii Natural Energy Lab, which does ocean thermal energy conversion even today in Hawaii. And Craig Allen and Carol Stimson were a part of his staff at the time. The next Law of the Sea director in Hawaii was Judge Thomas Mensah. So he went from the Law of the Sea Institute in Hawaii to being the first president of ITLAS. And he edited one of the books. So I just went through the many years of the executive board, so this isn't any one particular point in time, but these are all the different people who served on the board. At that time, there was a board for the Law of the Sea Institute, and as you can see, there are judges from ITLAS, people who became judges on the ICJ, ambassadors, and other very distinguished people, some of whom are here today. So when the Law of the Sea Institute started in Hawaii in 1977, the first conference was talking about the 200-mile EEZ, because it was already clear by then that that was going to have a profound impact on the law of the sea. Several of the participants predicted that national interests would lead to two declarations of exclusive rights to resources, and there was concern about whether or not UNCLOS was going to be able to anticipate and provide for cooperative regional arrangements for future resource management allocation. The conference focused on the development and comparison of regional arrangements that were already existing in Pacific, Caribbean, Western Europe, Southeast Asia. Ed Miles pointed out that regionalism in the law of the sea issues will only work if political trade-offs are possible. Those countries with nothing to trade off were going to miss out. You see, Doug Johnston was the editor of the proceedings from that time. And that first conference, in recognition of the move to Hawaii, the conference included a special section called the Pacific Caucus, where Pacific island nations were invited. And of course, this was the time when America's territories and other territories in the Pacific were gaining their independence. So it was very important to have this separate caucus for the new nations of the Pacific. Rata Sur Kamise Se Amara of Fiji, who was the first president of Fiji and led the Pacific Caucus, and he coined the term the Pacific Way, which promoted different kind of values, shared values, a desire to promote local rather than Western solutions to local problems, and also to work toward unanimous consent. Richard Bilder, who was on the LOSI Executive Council, also discussed the developing law and the impetus for regional arrangements, the obligation of nations to take the interests of other nations into account in determining their policies in such a context is reflected in the 1974 decision of the International Court in Anglo-Icelandic Fisheries Jurisdiction case and other international arrangements. The 12th conference was held at the University of Utrecht, and at that conference they wanted to discuss neglected issues that hadn't been included on the agenda for the Law of the Sea Convention. And Tommy Coe was at that conference, and the participants predicted that the Law of the Sea regime, this is all the way back in 1978, might not achieve ratifications by some of the industrial states, but would still enter into force because of ratifications by the number of the smaller states, less developed states. So some of the issues that were considered neglected issues were non-nodule resources of the deep seabed, airspace, the polar regions, and as you can see, Willie Ostrom was one of the people who presented on that issue, the changing regime for shipping, Edgar Gold, and energy sources from the oceans. After that, there was a workshop in Ka'u on the Big Island in Hawaii, and that was a special workshop just on the seabed mining. And a lot of people came from all different nations, and including third world diplomats. People came from mining consortia, and it was predicted at that conference, this is only 1978, that there would be a failure of the seabed negotiations, and that was going to be because of fundamental distrust. Okay, the 13th annual conference, there's just so much to talk about. I had to really pick and choose so we could make it through some of these conferences, but they were all so very interesting. So Tom Klingen was the editor of this conference proceedings, and that was in Mexico City. And we were invited by the Institute for Social and Economic Studies of the Third World, which was supported by the former Mexican president and Alvarez. And that we kind of looked at because the Latin American countries had promoted the concept of the patrimonial sea, which then later evolved into the EEZ. There was a lot of talk at that conference about the EEZ and the zones of special jurisdiction. So Mexico was among one of the first nations to establish a 200-mile EEZ, and the president President Alvarez had addressed the UNCLOS's plenary session in Venezuela, talking about the patrimonial sea, and had formally introduced this concept to the international community at that time. So Doug Johnston and Edgar Gold discussed the effect of this extended jurisdiction on coastal state practices, and Bernie Oxman analyzed the EEZ as formulated in the informal negotiating text. John Van Dyke disagreed with the 200-mile EEZ claimed by France for Clipperton Island, which was off the coast of Mexico. So that, of course, was of great interest to the Mexican academics and government officials who hosted the conference, and actually even disputed France's sovereignty claim because it was only supported by a newspaper article that appeared in a Hawaii newspaper in 1858. So the next conference was in Kiel, Germany, and Judge Chun-Ho Park was the editor of those proceedings. At that interesting meeting, there was a discussion about canals. For the Europeans, passage on canals is of great importance, and so that was one of the topics that was actually discussed at the Law of the Sea Institute meeting. So also because it was in Germany, there were discussions about the North Sea. So here were some of the many different things that were discussed at that conference, and some of the people who appeared to make presentations on the conference. Again, deep seabed mining was a topic of great dispute, and the four people who talked about it all took different points of view, and there was a lot of discussion about it. Ed Miles and Louis Alexander talked about international organizations and how would this affect them. The next conference, as you can see, we had a lot of help from the Canadians to edit these proceedings. Professor Wan Tiye, who was the legal advisor to the Chinese delegation and who later became a judge on the International Criminal Tribunal for both the former Yugoslavia and for Rwanda, stated China's position. And this was very interesting because the Law of the Sea Convention had just been adopted 7 weeks before this conference. And so I thought his comments were quite interesting in light of the current controversy that's going on in the South China Sea. So at that time, he said, as the legal advisor, well, of course he was speaking in his own individual capacity, not for the Chinese government, but he reiterated the position of China was quite clear, that natural prolongation should be the first basis for the delimitation of continental shelf boundaries, and the second was negotiations, and third, consideration of equitable principles. So I did read his whole speech, and I didn't see anything in there about the 10 or the 11-dash line. Okay, so then We had a very interesting discussion. I think back in those days, we were very grateful for the support of the Canadian petroleum industry for having these kinds of conferences because of their interest in offshore resources and the claims that Canada might be able to make. So they came and talked about Canada had this very interesting International Assistance Corporation at the time where they helped oil importing countries to help reduce their dependence. And the Canadian High Commissioner talked about the great importance of Article 76, Paragraph 1, and how it was incorporated into the Oil and Gas Act of Canada in 1982. The 17th conference, okay, we were very nicely invited by Willie Ostrom to go to Oslo, Norway in July, and we had quite an interesting group of people who were able to attend that. As you can see, we were reaching out to the Russians, and this, I think being in Norway, provided the opportunity for us to share thoughts with Russian academics and Russian high-ranking government officials. Bernie Oxman was the co-chair with Willie Ostrom. And we had Elliot Richardson attended that conference. And at that conference, we also had a very interesting presentation by the Foreign Minister of Norway. The next conference was in San Francisco. Robert Kruger and Stefan Riesenfeld were the editors. This was in 1985. And so there was discussion about what was the effect of UNCLOS going to be on the formation of customary international law. And there were many differences expressed. Chile Orrego Vicuna asked, does the convention entail nothing less than pure conventional obligations, and those states that do not become party to it are free, as those states that do not become party to it are free to pursue their interests by means of other approaches. John Norton Moore replied that outside the CBID area and possibly the dispute settlement chapter, today the UNCLOS test is the best evidence of customary law, absent a pattern of state practice to the contrary. And he actually rejected the pick and choose approach as he characterized it of the United States. Louis Sohn was present at that conference, and he commented that once an environmental law, rule, or standard contained in an international convention becomes generally accepted, a state party that is a party to UNCLOS, even though not a party to the specific agreement, has the duty to enact the necessary laws and regulations to implement that agreement. And we see ITLOS looking to state parties to enact necessary laws and regulations following that kind of a concept. David Colson gave the U.S. position on mining and said, it's a high seas freedom. His contention, of course, was later criticized by other speakers, and some people made the point that mining requires exclusive rights to the seabed for a long period of time. It's not something like when you fish on the high seas, and so it's not really analogous to other high seas fishing. Alexander Malahoff, who was an oceanographer, reported on new discoveries in the deep seabed with the polymetallic sulfides and cobalt crust. And Conrad Welling, who was part of the mining industry and had developed a ocean mining vehicle, he talked about the finances and the problems that were going to be faced. John Briscoe and his partner, Louis Claiborne, unfortunately I only have a picture of John, John was supposed to give me a picture of Louis Claiborne, but I'm still waiting for it to come. So they talked about the experience of U.S. Federal state management of marine and coastal resources and offshore boundary disputes that came about after the adoption, after UNCLOS. And they gave very interesting discussion on those issues. John Knaus, who later became the administrator of NOAA, talked about creeping jurisdiction in the ocean, and I think we've all mentioned. There were State Department officials invited from the U.S. State Department to argue the position of the United States, Brian Hoyle and David Colson. And then there were comments on those two arguments, Elizabeth Mon Borghese, John Bardock, Sir Rabi Namaliu, who became the Prime Minister of Papua New Guinea, Chin Ho Park, Ved Nanda, who's now at Denver Law School, and Professor and Dean Anand from India. So you can see the great breadth of people that were invited and attended these conferences, their great positions, and how it really was very much of international conferences. So Professor Anand espoused the position that the United States cannot expect to be taken seriously in the future if it just picks up its marbles and walks off because it didn't get everything that it wanted. Anatoly Kolotkin, who later became an ITLOS judge and was from the USSR, said that the development of the concept of the common heritage of mankind is a unique historical event that can have a significant influence on the present world and international order. The concept is directly linked to, quote, the idea of a new international economic order. Bernie Oxman concluded that the rights enjoyed by coastal states in their EEZ reflect customary international law, but it's foolhardy to expect that all of the restraints on coastal state action spelled out in the convention will necessarily prevail. And he predicted the convention would not be widely ratified, but of course that was in 1988 before the implementing agreement. Paul Ewan pointed out, he's from China, that decisions of the view in China at that point in time, and perhaps we're seeing this same kind of philosophy even today, seeing that international courts were regarded as being the result of manipulation by major capitalist powers. But of course, China does have and has had judges on ITLOS and the ICJ. China has adopted a, quote, pick and choose attitude toward both the ICJ decisions and the LOS convention itself. And China rejected the idea of the validity of the teachings of eminent publicists because they were educated by the bourgeoisie and therefore served their interests. Conrad Welling, again from the mining, Ambassador Jalal said that Indonesia wasn't going to allow those non-signatories to the convention the right of passage through their archipelagic sea lanes. Rabi Namaliu addressed the issues relating to fisheries, and there was a lot of concern over the U.S. refusal to accept coastal state jurisdiction over tuna. And that was very frustrating for Pacific Island nations. Bill Burke discussed fishing practices of non-signatory states and concluded that although the major provisions of the convention are commonly found in state practice and therefore reflect customary law, the accompanying details are not yet customary law. So then in the next conference was in Honolulu, and at that time President Reagan had excluded tuna from coastal state sovereignty in his 200-mile EEC proclamation, and Congress had passed a law, U.S. Fishermen's Protection Act, forbidding U.S. government from recognizing the rights of coastal states over their tuna, and so these disputes had resulted in seizing of U.S. fishing vessels and confiscation of their catch. So Hawaii was a great place to have a discussion on what should happen going forward regarding tuna in the Pacific. So Kiribati went ahead and entered into a deal with Russia, and of course then the U.S. got extremely upset and concerned about what was going on, and finally negotiated an agreement with 16 South Pacific island nations to form the Fisheries Agency that now continues to govern fishing of tuna in the Pacific. So the South Pacific Tuna Treaty entered into force in 1988, and this was a matter that was greatly discussed at the Law of the Sea Institute. It's the next conference, the International Implications of Extended Maritime Jurisdiction. Okay, that was the 21st conference in Honolulu. Judge Chun-Ho Park talked about the 1965 fisheries agreement that Korea had entered into with Japan, supposing to regulate fishing around the Korean Peninsula, so long as Japan helped Korea develop its fishing fleet, because at that time most of the fishing in Korea didn't even have motorized engines. So, but the Koreans were too successful in learning from the Japanese, and the Japanese got upset because they wanted to cancel the agreement because the great success that the Koreans had. And Judge Chun-Ho Park had such a great sense of humor, and I loved his comment. He says, one of our former prime ministers came up with a very peculiar idea of sinking the island, Dr. Takeshima, by bombing it. So you can see these themes are still around today. My comment at that time was if they decide to bomb it, then the two countries will argue for 15 years to decide which side will pay for the explosives, or which side will pay for the erection of a navigational aid that will say it is here or there on the chart. So we probably could just resurrect that comment and reuse it today. Judge Peck was at that conference, and as he mentioned earlier, he talked about North Korea's claim, and he talked about their straight baseline, that claim that they had made, and pointed out, I think, for the rest of us to learn from that, the coastline was not particularly deeply indented, and it seems very doubtful that the East Korea Bay and small indentation north of it would fall under the category of historic bays. Tom Klingen, okay, then the next conference was in Moscow. So that was quite exciting because we were able to go to Moscow, but that was in December, so the Russians didn't have the same good idea that the Norwegians had, have their conference in July. Anyway, so there was the conference in Moscow. Tom Klingen said the common thread between the topics of the conference was a mutual concern for stability of rule in the oceans, and talked about two kinds of stresses: the interpretation incompleteness of some of the provisions of the 1982 convention, and what was going to happen to those that didn't sign. Richard Palmer of the American Maritime Association noted that it almost seems like they would be bound by customary law. Judge Kolodkin said, today we can say frankly, if we want peace on land, we must disarm at sea. So that was quite a important statement to be being made back in those days. So the editors commented about the next conference, which was in Cardiff, Wales. So that was in 1985. And the comment was, whether the convention enters into force or not, and irrespective of the timing of that event and of the number of adherent states, the substance of the convention will have a major impact on the further development of international law. There were discussions about, already in 1985, there were discussions about how the law was developing and the predominance of geography over economic or environmental factors in maritime delimitation disputes. Judge Trevis analyzed the European Community's status as a signatory to the convention, and at that time Britain and Germany had not ratified the convention, and he tried to analyze what was the effect of the European Community signing, but not two of its larger members non-signing. Patricia Burney, Professor Burney, also commented in response, and she talked about the, what kind of uniform emission standards would be had in the EU, what kind of environmental protection there would be. The next workshop in 1988 in Hawaii was Lou Alexander and Joseph Morgan and John Van Dyke were the editors. And Lou, again, talked about creeping uniqueness, the feeling by many nations that their geographic circumstances are somehow unique, and therefore they're not bound by the strict interpretation of the convention in one or more respects. So I think creeping jurisdiction and creeping uniqueness are factors, issues that we're still seeing today. Judge Chun-Ho Park talked about the Korea Strait and a very ingenious solution between Japan and Korea in terms of allowing for navigation and not making a full territorial sea claims. The next conference was in Rhode Island. Judge Mensah talked at that conference about freedom of navigation and a number of other things. So this is a picture of Judge Mensah today, Permanent Court of Arbitration, with his fellow judges deciding who are going to be issuing rulings on the dispute in the South China Sea between China and the Philippines. Satyanandan talked about the convention, and he expressed his concern about increased tanker traffic. So, we're looking at almost quite a while ago, but people who are involved, like Satyanandan, recognizing what the future is going to bring. There was a talk about by Brian Hoyle, who came to promote the position of the Reagan administration and explain that the U.S. is sufficiently satisfied with the rules articulated regarding the territorial sea, and that the United States was going to adopt that, whether or not we ratified the convention. Of course, later that same year, President Reagan did declare a 12-mile territorial sea. There was a 25th anniversary celebration in Malmö, Sweden, and Lou Alexander was there, worried about the annual fish catches, already pointing out that fish were diminishing and that we already had a problem. He harbored dreams of a complex ocean mining system and a widely ratified treaty in force to administer it. He also looked forward to the Law of the Sea Institute surviving to its 50th anniversary. And of course, we're here today. We're honored to be here today to be able to celebrate that. The Undersecretary to Sweden's Ministry of the Environment pointed out that the key to development is safeguarding the environment and the natural resources in a sustainable way. And at that conference, most of the participants echoed his call for better cooperation to preserve and protect the marine environment. Someone was there from IUCN and supported the concept of a holistic and integrated management approach to the marine environment. Then the next conference was in Korea in 1993. And that conference was co-sponsored by Cordy, which is the precursor of kiosk. So I think I want to really give you an idea of how much dedication and loyalty we've been receiving from the Korean Institute of Ocean Science and Technology. And that proceeding was edited by Sun Young Hong, President Hong, formerly from INHA, Edward Miles, and Judge Park. So Judge Sunji Yanai was there from Japan and explained why Japan had not yet ratified UNCLOS. I think it's probably, he was also concerned about passage through the various straits of Japan, but of course Japan was trying to be a loyal partner to the United States as well. Philomene Verlan talked about the economic costs of disregarding environmental factors. Dr. Jun-Soo John explained two new concepts in the field of shipping and fisheries, floating container terminals to deal with congestion in Incheon, and efforts to implement a new distribution system. There was more talk, of course, about deep seabed mining. President Hong explained that the Korean government was very interested in deep sea mining, and here's the chart of today in the Clipperton area, and as you can see, Korea is one of the pioneer investors and very active in that activity. Elizabeth Mann Borghese made some great statements in favor of the conference, of the convention. This was the 28th conference. We're almost getting there. We're almost at the end of the Hawaii years. And this volume was edited by Judge Mensah. She observed that the convention occupies an advanced position on sovereignty. It limits sovereignty by making peaceful settlements of disputes mandatory and creating a regime to do that, by subjecting sovereign rights over resources to the duty of conservation, environmental protection, and even sharing, by imposing the duty to cooperate. And she said it transcends sovereignty through the concept of the common heritage of mankind, a concept of non-sovereignty. Louis Sohn, he talked about the ingenious boat paper, which became the agreement, made possible adjustment of the convention to the new circumstances of the 1990. I think maybe back to the question that was posed to Judge Peck, he said the dispute settlement provisions of the convention should help to ensure that the peace of the world will not be jeopardized by a dangerous escalation of the law of the sea controversies. Peace, justice, and the rule of law will be our reward. So I think this is very important for all of us as people who are talking about the law of the sea convention and the dispute matters. I mean, that's always the end result that we hope for the rule of law, is to achieve peace and justice. So I want to say mahalo nui loa to LOSI Berkeley Law School from Hawaii. Congratulations on your 50th anniversary conference. And a special mahalo nui loa to Professor Harry Scheiber, Jane Scheiber, Jordan, Diamond, Karen Chin, Tony Mendocino. And I also want to give a special thanks to the Korea Institute of Ocean Science and Technology, who's been such an incredibly loyal supporter of the Law of the Sea Institute all these many years. Thank you.